was knowing who I am. And when you're young and you're in your 20s, you're trying, I mean, at least I was, you're trying on personalities like they're shirts. I mean, you're literally just, I'll be this person, I'll be that person. And one day you've stolen from 1,000, so you're a genius, not a thief. And instead of stealing from one, and you've pulled all these different references in and these feelings, and you know yourself. And it's that, a lot of people, when they talk about things, they frame it like a TED Talk or something where it's like, I knew at the time.
Hey friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. There has been so much chatter about Blake Lively and Ryan Reynolds and Justin Baldoni and the disclosure of records to Stephanie Jones through this sham lawsuit and the subpoena. And there's been a lot of discussions about what the New York laws are around subpoenas, whether or not it's legal. And here's the thing. New York has very liberal laws when it comes to subpoenas. And technically, a lawyer can issue a subpoena to a party in the case without the signing off of a judge or a clerk, because under the law in New York, they have the authority to issue a subpoena as long as there's a case. However, a subpoena can be declared invalid if it can be proven that the case was either irrelevant, was done in bad faith, the scope of the subpoena was too broad, or improper or insufficient notice was given. And Wayfair has stated that they believe that Lively concealed her identity through the Van Zandt Inc. lawsuit, sued no one, so she had to notify no one, and then handed over records to Stephanie Jones. And then Stephanie Jones, an employer of Jen Abel and a publicist of Wayfair, disclosed confidential information to Blake about her ex-employee and her former clients without notifying them in any capacity. And technically, under New York law, you don't have to notify subjects of a third party if they're not named. So, for instance, if she didn't subpoena Jen or didn't subpoena Justin, if Stephanie gets the subpoena, she doesn't have to tell Jen or Justin about it, technically. But that doesn't mean that if it's discovered that information was provided via subpoena and that the lawsuit was done to avoid or to get around having to notify the people being targeted, that's where the bad faith part comes in. And now we're starting to learn even more information about why the subpoena was released. We know the subpoena was done because Wayfair has alleged that on August 21st, Stephanie Jones disclosed confidential information to Blake Lively about Baldoni and Wayfair and Jen Abel the day she fired Abel. Stephanie Jones, who had been completely a part of everything, by the way, it wasn't like Abel went rogue. Stephanie was involved and gave feedback on Melissa Nathan. She provided feedback on what she would do for crisis management. She interfered and interjected with the Daily Mail. She actually referred to Blake's claims of sexual harassment and improper, making her feel uncomfortable on set as a nothing burger. But once she got fired by Wayfair, then suddenly it was a smear campaign designed to destroy Blake Lively. Right, Stephanie? Either way, they had to fix that because, one, Blake doesn't get to have confidential information from someone just because she wants it. And two, Stephanie could have been sued by Jen and by Baldoni and by Wayfair. So how did the subpoena get leaked? Why did it get leaked? What was the catalyst? Well, the catalyst was because Baldoni and Wayfair, along with Abel, filed countersuits against Jones and alleged that what information was revealed to Leslie Sloan or the Blake Lively parties by Jones without a subpoena. They baited her, in a way, by saying there was no subpoena. And right now, I would say it's debatable that the subpoena that was used is valid. It'll be up to a judge to decide, but there's a lot of shadiness that was involved in how that was issued. And there's a lot of steps they can take, which we talked about yesterday, from sanctions to abusive process claims to summary judgments, trying to get the evidence thrown out, trying to do code of conduct, ethical violations for the attorneys. And then there's like this whole concept about the far fetched idea about obstructing justice, contempt of court, possible criminal liability. Although I really don't see that happening. It can happen in some cases, though most civil cases do not lead to criminal charges unless in the process of a civil lawsuit, information is revealed during discovery that crimes occurred. So that's kind of how it works. And if crimes occurred, it's not Brian Friedman that prosecutes it. It's a US attorney or it's a prosecutor in whether it's New York or California. But as far as the civil case, criminal charges are not added to a civil case. And right now it remains civil. Now, the person that leaked it is unknown, although we know it was leaked the same day that Miss Jones responded to the motion or to the counterclaims with a motion to dismiss. And she stated she did have a subpoena and she was only providing this information because a court demanded that she turn over and produce these documents. And information was getting kind of leaked bit by bit. And every single time the subpoena was discussed, whether it was on Daily Mail or Deadline, it did not state what the lawsuit was that the subpoena was attached to, which was the first red flag for me. The other thing was that they did not state a case, like the case number or where it came from. And so we first get these articles that are like, see, there is a subpoena. We saw it. It's from a court. Everything's fine. And it felt like it was being done by someone connected to Jones because Jones' attorneys also made comments about, we responded under the law and we had to do it and we complied and blah, 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 And then next, the Daily Mail digs into it a little bit more and they're like, oh, it was actually issued through New York County courts, but there's no stamp, which, by the way, in New York, you don't have to have a court sign off on it. An attorney can actually issue a subpoena. But the fact that it was issued in New York County is how I then located the Van Zandt Inc. lawsuit. And that lawsuit had no defendants, and Stephanie Jones wasn't listed. And the defendants were supposedly Blake Lively's own employees. So it begs the question how Justin Baldoni and his records are relevant to that case. And that's where the whole bad faith and abusive process claims that are coming in and the unethicalness of all of it and what the outcome will be for that Wayfair and Baldoni have been stating through Brian Friedman. But the documents were leaked to the Daily Mail and to Deadline. And the journalist for the Daily Mail, who is from England or the UK, said that on Ask Two Lawyers, he said that the individual, his source, showed him a photo or showed him the subpoena, but he was not allowed to publish it. He was not allowed to share where it came from. He wasn't allowed to reveal the source. He was just showed that here it's real. This is what it was from. He was allowed to see what the subpoena sought, but he was given some instructions, like they were not to disclose some of the details of what documents and information was being targeted as a part of the subpoena. Deadline then yesterday revealed that they were after Jen Abel's phone. And in an article, it said that the subpoena was looking for electronic records, data, documents, and communications in your possession, custody, or control collected from a cellular phone containing the requested information from December 1st, 2022 onward. Now, here's the issue here is that Jones, who is an employer of Jen, was using Jen's phone. And if there was confidential information or private information, like her date of birth, her social security number, medical information, doctor's information, psychiatric information, protected information, privacy information that shouldn't have been disclosed, there was no one advocating for her on whether or not that was going to be handed over to Lively through the Van Zandt lawsuit. And as an employer, she probably should have considered that because even though under the law, it's not illegal to disclose that, she can still be liable for disclosing that with not at least taking the steps to notify her employee or her former employee that records are being sought in a third-party subpoena. Because you know what Jen Abel would have said is, who's Van Zandt Inc.? What do they have to do with me? And she could have fought the subpoena, right? So the journalist believed that whoever leaked it, the source that they know the identity of, was doing this because they wanted to stop the narrative in the public that there was no subpoena. But what I thought was weird when all of this happened, and I still think is weird today, is why hasn't a copy of the subpoena then been provided to the court? Why did the source care about the narrative in the public about the subpoena more than what was going to happen in court? Because if it was issued in court and it was listed as an attachment, then the subpoena becomes public record. And then any of us could look at that subpoena. Well, I kind of feel like the reason why they didn't reveal it was because we would want to know who's Van Zandt Inc. And why did Van Zandt Inc. think they had any right to the records of Jen Abel and Baldoni and Wayfair and Jamie Heath? And why was Stephanie Jones getting a third-party request from Van Zandt Inc., who is unaffiliated with all of those people, about reputational damage to Blake Lively and Ryan Reynolds, but not to Blake Lively and Ryan Reynolds directly, but to their company, Van Zandt Inc. I think that's why it wasn't put in an attachment. And I think once it became a public record, it was going to become a storm of why would they do this? This seems weird. And now today, the attorneys are saying, what we did is normal and everything is fine. This is all legal. It's above board. They're doing faux outrage because we uncovered their smear campaign. Now, the problem with that is that we've seen most of the text messages. We've seen the ones that have been picked and cherry-picked by Lively to prove her point of a smear campaign. We've seen the replies that don't prove a smear campaign. We see them not taking credit. We see them joking that it's not them doing it, but Lively will accuse them of doing it, almost like she's doing right now, right? I also believe the subpoena being done this way would make Blake and Ryan and JonesWorks and all of the parties suing Wayfair look like hypocrites because they demanded a court give them these uber highly confidential designations in discovery to protect third-party confidential trade secret information. And yet, Blake Lively, through Van Zandt Inc. and Stephanie Jones, didn't seem to care about violating the third-party confidential trade secrets of Wayfair Studios or Jen Abel or Justin Baldoni. They didn't care about violating the privacy through this subpoena, but then on their case, they're trying to claim that Wayfair is the dangerous one that's going to use that information to destroy them. And they even said that the information they have is so salacious and it is so tantalizing that in the hands of the wrong people, they would want to run to the media and destroy the careers of the people involved. Does anyone remember what was actually said by her attorneys when they argued for this in the court? This was their argument, Lively's argument to the court on March 6th. Unlike in typical cases, the parties in this case on both sides of the aisle include people and businesses whose entire living is made off of providing information to the press and content creators. I'm not intending to be pejorative. It's just the reality of what they do. They make money and to stay in relationships by trading information with them and having techniques for doing so off the record and on background. And in fact, a particular note in this case is the defendants themselves have bragged in text messages about being able to do this in an untraceable way, of being able to publish information without fingerprints, and also having individuals who will do anything for them who hate Miss Lively. So we'll pursue further evidence of this through the course of discovery, but the evidence in this case so far demonstrates there's a significant risk, unlike others that perhaps have been before this court. So they were trying to say that Baldoni was going to take the information they gave them in discovery and put it out to the press and do it in an untraceable way, which sounds a lot like what Blake Lively did by trying to use an untraceable lawsuit in the state of New York without her fingerprints on it and using individuals that would do anything for her because they hate Baldoni. I kind of feel like you could just reverse Uno that. But they were trying to make it seem like it was Wayfair that was doing these things, even though it was kind of they were the ones doing it, right? They also argued this. There is an insatiable appetite for any information about this case, no matter how salacious it is. We've seen even the most benign and routine information become tabloid fodder. And just this week, for instance, Your Honor, the Daily Mail published a story on an insider source with information from Mr. Baldoni's legal team about the first group of potential witnesses who Baldoni's team want to hear from and who have been contacted but not yet scheduled. So even the prospect of discovery, and so it's not a stretch for the court to imagine the harm that could come from actual discovery information being placed in the wrong hands. So they were concerned about discovery being leaked to the tabloids, and they were trying to place it on Wayfair being the culprit. And yet somehow a subpoena that they haven't disclosed to Wayfair ended up in the hands of the media because the media has, like they said, an insatiable appetite. They were accusing Wayfair of doing stuff like this, and yet they were the ones that did it. So I feel like part of the reason why this was being withheld is because it doesn't match their arguments about Wayfair, and it kind of proves they're playing dirty. Then add into it an argument they made about third parties like what they did with Stephanie Jones, okay? She was a third party subpoena in that case. She was not listed as a defendant or a plaintiff. And they argued there will be significant third party discovery. And we think there's a significant chance of irreparable harm if marginally relevant communications with high profile third party individuals who are unrelated to the case were to fall into the wrong hands. And they further drove home their need for this AEI, like the attorney's eyes only. They said that there was such a high PR value for this information that it could do irreparable harm to third parties. Just like what Blake and Stephanie did to the third parties that weren't a part, that were targeted in that subpoena, and then that information was used as PR because it had high value in the PR world, right? And it caused irreparable damage. So they wanted to protect their third parties, but they didn't care about invading or exploiting third parties like Baldoni. So if you can't walk the walk and talk the talk and practice what you preach, I think that's part of the reason why this subpoena was leaked this way, because they didn't want it to all come out at once and it would be less of a big story. That's my opinion. But they argued if information about third parties is released, it could be damaging to their reputation and privacy, and that the government has a substantial interest in preventing that sort of abuse. She was accusing Wayfair of the possibility of abusing her clients by running to the tabloids. Okay. And yet they did that too. And then later, her attorneys said this. So let's take a complete hypothetical that I would not have access to. Let's say that Mr. Baldoni has a very good friend who is very high profile, and he was just venting about his day, and he mentioned something about our clients in connection with that, what happened on the film. That would be responsive, arguably. That would potentially be relevant. It's a communication by a party about another party, but its value to the case, its necessity to the case, evidentiary value would be overshadowed by the fact of who he was communicating with. If he was communicating with a high-profile individual, that's all of the sudden what creates significant PR intrigue for a communication that to a friend who has a completely private, anonymous individual would not carry the same kind of weight. So they were worried about third parties getting their rights violated, their privacy violated. And yet, Jen Abel's privacy was not thought about. Baldoni's privacy was not thought about. And he, in that New York case, was a third party. And see, they argued so hard for this after losing and having a subpoena quashed. And they've been making it difficult in discovery for Baldoni and team because to date, they still don't have a copy of that subpoena. All of this is gamesmanship, and it's a way to control the narrative. because they were accusing Wayfair of doing what they had already done. So again, my belief is that a trap was set by Friedman to finally suss out the validity of the subpoena, to get to the root, to force their hand to disclose it. And the subpoena was listed in a claim, which would force the discovery and the disclosure of the subpoena. Okay. We know that so far, any attempts by Lively to get phone records have been quashed under the same circumstances that she requested information for phone records in the federal case. So I don't think the court is going to be looking very fondly on what she did in the New York case by not notifying anything. And then also putting this judge through a runaround, making him believe that Wayfair was the actual threat here, Wayfair, and no one else. And there is some evidence that has been put out by Baldoni through their attorney. We've seen the video, the unedited video, which was evidence, right? We've seen and heard a phone call or a phone voice memo, but they've not put out any legal records about anyone. So they haven't put out subpoenas or confidential information or documents or anything like that that could potentially have exploited someone or caused harm to someone, right? They just put out refuting evidence. That was it. In this case, the subpoena is such a contested point of the lawsuit. So instead of going to the court and giving it to the court, they had such high PR value for that subpoena that instead they gave it to the Daily Mail and they gave it to Deadline. And they discounted and completely disregarded all of the order of the court when it came to discovery. That piece of information, that subpoena, is a part of discovery. And once discovery is opened, you generally don't disclose the pieces that are of discovery during the discovery process. And they are disclosing discovery publicly before it's ever been provided to the court. It's a mess. And guess who's doing it? Not Wayfair. So my final moment here is that I've had a chance to connect with a couple people connected to Baldoni. And I don't want to say who I've talked to or what was said in its entirety, but I wanted to make sure that, one, I'd never made contact with anyone related to him, connected to him at all. I just wanted to make sure that everyone's doing okay. And I asked how everyone's doing. And I was told that it's been an absolutely devastating experience. It's been horrible, beyond comprehension for his family, his friends, his extended family, and his business. His entire life is completely shattered, literally and figuratively. And they did not know about this lawsuit. I asked. They were shocked when they found out, but they weren't surprised. They weren't surprised because they knew that they had done something to obtain those records. They had already had experience with how dirty these people play, that it's become the norm for them. It's almost like it's disheartening and it breaks their hearts that this is what happened. But at the same point, it's become so normalized. It's become just a part of every day with them that, oh, okay, so this is what they did. But it sounds like having to deal with Blake and with Ryan and with these people, it's like walking on eggshells or landmines and never knowing what was going to happen. Like it being that hostile. At least that's how it was in the words that were spoken to me. And also, I asked them about the smear campaign and I made a comment about, I noticed that a lot of this seemed to happen from Colleen's fans. It seemed to come out organically from her Facebook group, and there had been backlash about the wardrobe. There had been backlash about the castings. There was backlash with Colleen. And I even said about the book, the coloring book, the It Ends With Us coloring book, and how that promotion and Colleen trying to capitalize on it caused a huge backlash from her fans, and that Lively should have known that this promotion wasn't going to work based on what happened to Colleen. And all they said was no smear campaign happened, and it all originated from who? Colleen Hoover's fans of the book and book talk, and these loyal survivors that didn't appreciate the downplaying of domestic violence and who also found the self-promotion tone deaf. And they didn't have to do anything. Never happened, they said. Sexual harassment, they said, never happened. It's all just some sort of game that they don't really even know what the goal was. So I did let them know that everyone is thinking good thoughts, sending well wishes, hoping, and, if they're people that are praying for them, and that at the end of the day, everyone is fighting for truth and everyone's fighting for transparency, and every person just wants justice for Justin and for his staff and for his wife and for Jamie and Jamie's wife and all the women involved in this case, Jen and Melissa and Jed Wallace. And they appreciated the support. They're paying attention. They appreciate the support because it's felt very hopeless for them. So at least in that way, I guess we're doing a little bit to help, but they certainly weren't feeding me any information for a smear machine. They basically just confirmed what I had already found online, which was that there was no smear machine. So, what are your thoughts about all of this? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel. And do you think Brian Friedman's trap is what got this all out with Subpoena Gate? Tell me in the comments below. Thanks so much for watching. Bye, guys.